I'm going to begin the presentation by talking about medical debt, and I'm going to be followed by Tashi Liwa, who's in Legal Aid's Consumer Law Unit, and he's going to go into the debt collection practices and litigation aspects. Medical debt, as you all know, is particularly onerous because it's often sudden and unplanned and unavoidable. And the debtors can be especially vulnerable because they're suffering from illnesses or infirmity. And it's complicated by the fact that not only is it expensive, but often uninsured individuals are charged more than people who are covered by private insurers or Medicaid. Also, there are hidden costs in medical debt. For example, if somebody goes to a provider at a hospital, like a surgeon, knowing that they have a certain insurance and that the surgeon takes that insurance, with private insurance, there's not an obligation for, let's say, the anesthesiologist that's hired or put on the case when they're not able to make that choice to be in the same plan, and they wind up waking up with a huge medical debt. Medical debt is the major cause of bankruptcy, a major cause of bankruptcy, and can result from consumers either being uninsured or underinsured. Right now, 2.6 million residents of New York State do not have health insurance. This will improve with the Affordable Care Act. However, 1.6 are going to remain uninsured after full implementation. Now, today's roadmap, I'm going to talk about what advocates can do to help consumers avoid or eliminate medical debt. And I'm going to do this by talking about how you can recognize improper billing of Medicaid recipients, and then how you can enforce implementation of the Hospital Financial Assistance Act. And then Tashi's going to talk about debt collection practices, laws and regulations governing, and litigation practices. Now, to begin with, advocates representing clients with medical debt should be aware of powerful consumer tools at their disposal. In our practice, we rely heavily on various laws and regulations that prohibit providers from seeking payment from Medicaid beneficiaries, and also on the Hospital Financial Assistance Law. Often, reliance on these laws enable us to reduce our clients' debt significantly, even after the debt has been sent to collections, and sometimes even after the client has been sued. The Federal Medicaid Act and Regulation is a state, Medicaid, you know, is a state and federally funded program, and the Federal Medicaid Act is implemented by federal and state regulations, requires states to limit participation in the Medicaid program to providers who accept Medicaid payment as payment in full, other than cost sharing that the program might require. To participate, all providers must agree not to charge any individual for services which the individual is entitled to have payment made. Balanced billing, which is the practice of billing differently, the difference between what the insurance is going to cover and what the provider's usual and customary rate is illegal under the Medicaid program. And I have to say that we have recently been contacted by somebody who was being asked to pay for ophthalmologic services, I think hearing aid, that the patient was being billed for what Medicaid didn't pay. So it's still going on, and it's something that you definitely need to be aware of. New York social services law doesn't expressly prohibit recovery of costs of treatment for Medicaid beneficiaries. However, some of the sections have been construed as not being compatible with direct liability on the part of the eligible recipient. And there are different sections here that you can look through at your leisure. But there are the common law prohibits direct billing of Medicaid patients. But the law itself does not expressly prohibit it. Hospitals have a duty to assist with eligibility determination, and this comes from New York State common law. It's been interpreted as imposing on the hospital the duty to ascertain possible eligibility and to give adequate direction and information to maintain continuing sufficient interest to ensure that eligible patients or their families have filed required applications. The bottom line is that Medicaid patients simply can't be billed. The only situation in which a Medicaid beneficiary can be billed for medical services is where the Medicaid provider informs the patient prior to providing the service that the service doesn't qualify for Medicaid coverage, and where he obtains the patient's consent to be billed on a private pay basis before providing the service. This means that in order, and usually they like, this should be in writing. So before the provider can tell the patient that they're going to be billed, they have to advise them ahead of time. I don't accept Medicaid, or this service is not covered by Medicaid. I'm happy to treat you, but you must pay. This must happen before the service is provided, and this should be put in writing. If they're not told in advance, they cannot bill this Medicaid patient, even if the coverage is not, the service is not covered. Now, emergency services are those needed to evaluate and stabilize an emergency medical condition, and they must be covered by Medicaid and Medicaid managed care. So if somebody goes into the emergency room, out-of-network providers must accept payment in full. There are no co-pays that can be collected, and the out-of-network providers have to confirm eligibility and advise the patient if post-stabilization care is not covered. So when they first go in, the emergency part of the service is absolutely covered, regardless of whether the provider is in-network or out-of-network. However, there comes a point where the physician has achieved stabilization of the condition. At that point, the services after that point, they can be charged, but they have to, there are certain rules, and it's in the model contract about how long you have and what the provider and the hospital must do to advise, to contact the plan, and to find out whether or not out-of-network services can be approved. If nothing is done and the providers and the institution don't do anything to contact the person's health plan to find out what to do next upon stabilization, then the person will not be responsible. So the thing to do for advocates to do is to alleviate the debt by uncovering improper billing. When you get somebody coming in, first thing to do is determine, was the patient covered for the active date of service? And then find out if the provider accepts Medicaid. And that, make some calls, find out yourself if they are Medicaid providers. And then if you find that they're still billing the Medicaid patient, to advise that provider that Medicaid patients cannot be billed. You can send them the Medicaid update. And also the State Department of Health has issued a guidance letter to the Medicaid managed care providers. The letter is old. I think it goes back to about 2003, I think, but it's still valid, and we often use that to send to providers to advise them that they cannot bill Medicaid patients and the limitations. If the other thing to do is if you have more than one insurer, make sure that the insurers are billed in the correct order, because sometimes the claim will be denied if it's submitted out of order. This brings us to a discussion about the Hospital Financial Assistance Law. Now, Public Health Law 2807K places limits on the amount that hospitals can bill low-income patients who have inadequate insurance and prohibits abuse of collection practices. It's been a major step in combating medical debt. And it's been effective since January. It was implemented as of January 1, 2007. All hospitals licensed by New York State Department of Health are required to implement uniform policies and procedures for providing financial assistance to those without coverage for services they seek and who can demonstrate an inability to pay. Hospitals have a discretion whether or not to reduce copays and/or deductibles. We found that some do and some don't. So it really is in their policy. And I know that the policies are all uploaded on the CHA website. So if you have a question about a particular hospital policy, just check the website and it'll be available to you. Major provisions of the Hospital Financial Assistance Law. The law links the fees that can be charged to the highest volume payer who can negotiate the most favorable rate. So those individuals whose income is at or below 300% of the federal poverty level are presumptively eligible for payment adjustments. And the charges are adjusted according to a set formula based on the federal poverty level. And those formulas are set in the law. The law permits hospitals to provide discounts at a higher rate. Some actually provide a reduction well over 300%. There are hospitals in the city that we know of that go up to 400% of the federal poverty level. It is within their discretion, but many don't. Many stick within the parameters of the law. And this applies to general hospitals only. This does not cover providers. So sometimes even if someone has a bill and they go to a hospital and ask for a reduction in the bill based on the hospital financial assistance law, it does not cover the provider's bill, just the hospital's bill. Now, patients with income at or below 100% of the federal poverty level can be charged no more than a nominal payment. And the nominal payment is the payment that's been defined in accordance with ceilings established by New York City Health and Hospital Corporations by their HHC options program. And this was in existence actually long before the hospital financial assistance law. HHC has really been a leader in assisting patients reduce their bills. And so the ceiling, the nominal payment is $150 for inpatient care, ambulatory surgery. It's $15 for adult emergency room or clinic, and nothing, zero, for pediatric emergency, for pediatric clinics, or for prenatal visits. And that, like I said, is written in the law. Now, the fee structure, as it's for those other than the nominal level, is linked to the standard charge. And the standard charge is what the hospital would have been paid by its highest volume payer. In other words, if you look at last year and see who was the payer that paid the most, the highest volume payer for the year before, or Medicaid or Medicare, whichever is the highest amount. And so for those whose income is between 101 and 150% of the federal poverty level, the hospital is only allowed to charge up to 20% of the standard charge. Between 151 and 250, they can go from that 20% of the standard charge to the maximum standard charge, and then up to 300% of the federal poverty level, they can charge no more than the maximal standard charge. Now, as far as consideration of assets, it's allowed for patients with income, only those whose income is up to 150% of the federal poverty level. But this procedure has to be, the policy and procedure must be in writing, and it has to be approved by the Commissioner of Health. So once again, if the hospital is asking for information about assets, you should check their policy, which is on the website, and find out if that hospital has been approved to consider assets. Not all hospitals have applied to be able to consider assets, so you just need to check the policy. And hospitals can consider only savings that exceed the Medicaid resource level. And that is, for the 2013, that number is $14,400 for a household of one, or $21,150 for a household of two. So there are some exempt assets, but even if the asset is considered, the amount still can't exceed the standard charge, which is what the hospital could have collected from the higher of the highest volume payer of Medicaid or Medicare. Now, protecting the community access to hospital services. Hospitals must provide financial assistance for emergency services for all New York City residents. So if it's an emergency, regardless of where you are in New York State, if you're traveling, if you're upstate, downstate, the hospital must provide financial assistance for those emergency services. For medically necessary services, they only are obligated to provide financial assistance for patients residing in the primary service area. So for New York City, that's all 5 boroughs plus contiguous counties. For upstate, that area is the particular county and the contiguous county. But if it's an emergency, then any hospital has to provide financial assistance regardless of where you are or whether you're in or out of the primary service area. Another important thing to note is that there are no immigration requirements on the financial assistance law. We have seen hospitals ask for this information or say that they're not eligible, and that's simply wrong. The law requires that hospital policies and procedures be clear, understandable, in writing, and publicly available. It must be available during intake and registration. It's got to be available on all bills and statements that go to patients, and it's got to be conspicuously posted in language-appropriate material. Hospitals must ensure that every patient is aware of a financial assistance policy. And if they ask, they have to provide a summary. The summary won't be provided unless they ask. And the summary includes the income limits, and that's where you will know whether or not that income is 300% of the federal poverty level or if that particular hospital exceeds it. They have to tell you what the procedure for applying, and they have to tell you what the hospital's service area, it looks like a typo there, sorry, should be PSA, the hospital's service area. Now, required policies and procedures. Hospitals are required to implement a mechanism for measuring compliance with policies and procedures. They have to include, the policies have to include clear, objective criteria for determining the patient's ability to pay and providing adjustments to payment requirements that include the use of installment plans. And the monthly payments that can be asked to pay can't be any higher, must be lower than 10% of the individual's gross income. And the rate of interest, they can charge interest, but the interest can't be above the 90-day security issued by Treasury notes. And any acceleration clauses triggered by higher payments are prohibited. Applications must provide notice that the bills can be disregarded until the decision is rendered. So they have to tell the patients that they have to wait until they get the information, including the information, any documentation that's necessary to determine eligibility, that the patient can disregard any bills until the hospital has rendered a decision. The policy, patients have 90 days from the date of service to apply, and then after the application they have 20 days to complete, which is really more like 110 days. But in fact, we have seen hospitals accept applications for much, much longer than that, actually up through several years. But the law says that they have 90 days from the date of service. The applications can't be unduly burdensome or complex. And I know we've seen these, that they are unduly burdensome. Many of them that have been presented to us, we see hospitals asking for information like tax returns, and that specifically is something that they're not allowed to do. It's got to be can't be unduly burdensome. They can't ask for it for complex information, and the hospital has to assist the individual upon request. Individuals can ask to have the application in a language that they can understand, and the hospital's got to print the languages of 5% that is either used to communicate during at least 5% of patient visits during the year by patients who can't read or speak or write or use on English at a level proficient to understand it, or 1% of the census tract. And if it's not within that, if they don't have them printed based on those guidelines, then they, of course, can always ask for assistance, and the hospital is obligated to give them assistance and provide translation. Now, decisions and appeals must be made within 30 days of a completed application. The law says it must be in writing. The truth is we've seen many determinations made that aren't in writing, but the law says that it must be in writing. It must include information about the appeals process. Each hospital has to have an appeals process. And hospitals also can require patients to apply for Medicaid if they believe they're eligible. Now, they can't require them to apply for Medicaid and get a decision before they accept the application, But if they think that somebody is eligible for Medicaid, they can require them to apply at the same time that they're considering their application.
And they can't send it to collections while they're waiting for it.
They cannot send it to collections while they're waiting. Correct. Now, the limits on collections. Hospitals can't force a sale of primary residence to collect outstanding bills. Hospitals must refrain from sending the accounts to collections while the application is pending. And they have to provide notice at least 30 days before referring to debt collection. They have to let somebody know that they're going to be sending it. Now, collections agencies must follow the hospital policy and procedures. So whatever the law says about what the hospital has to do, the collection agency that is hired by the hospital to collect the debt have to follow the same policy and procedure. They also have to require the agencies to collect the written consent prior to commencing legal action. So the hospital can't plead ignorance if they didn't know it was going to collection. The hospital has to give written consent before the collection agency commences legal action. And they must require the collections agencies that they have retained to collect money to follow their own financial assistance policies and procedures, including they must provide information to the patient on how to apply for financial assistance. Accounts of Medicaid patients can't be referred to collections. So if somebody is on Medicaid, obviously it goes back to the first part of our discussion, where Medicaid patients can only be billed in a very circumscribed situation. Hospital policies and procedures prohibits the collection from a patient who is determined eligible for Medicaid at the time the services were rendered, and for which Medicaid payment is available. To comply, hospitals are required to follow yearly reports with the State Department of Health to assure compliance. If there are any complaints, you should certainly file a complaint with the New York State Department of Health. The phone number is there, and also their website. Now, informal advocacy. It's important to find out if the hospital, the first thing to do is find out if the hospital told the individual about the availability of financial assistance. Because remember, it is their obligation. If somebody is below 300% of the federal poverty level, they must give them information about the availability of financial assistance. It's got to be on bills, and it's got to be posted. And so if they haven't, request to submit an application. Also, alert the provider that the obligation is lower than stated. In other words, if you find somebody who, if the hospital is reducing it by a certain percentage, always check the parameters in the law and find out if they follow those parameters. So in other words, if somebody is below 100% of the federal poverty level, they can only ask them for a nominal charge. If you have somebody who's below 100% of the federal poverty level and they're asking them to pay close to the standard charge, clearly that's wrong and that violates the law. You need to bring that to the hospital attention and say, under the term, thank you for providing this. However, under the terms of the financial assistance law, this person is required to is only obligated to pay within these parameters. And so bring this to the hospital's attention. And if you're also working with a client who has a bill from a provider that's outside of the mandate, like say a physician, it's not covered by the hospital financial assistance law. We recognize that. However, it's important to tell the provider that you've already submitted an application to the hospital. And in fact, the hospital has considered this patient's income and made a determination based on their situation that they're entitled to significant reduction of their bill. And so you're asking them to, even though you recognize that they're not obligated by law, you ask them to recognize and to follow the same parameters because, the investigation's already done. The hospital's already determined that this patient really can't afford to pay anymore. So I guess I'm going to stop my presentation now and ask if there are any questions before Tashi starts.
I guess I have a question that has to do with the prohibition on billing the Medicaid eligible individuals who also have other coverage.
Right.
So say I'm picturing a scenario where an individual might go to a provider and provide their primary insurance card, and that provider may subsequently balance bill them for whatever was left over, being unaware that that person had Medicaid as secondary. Is the provider prohibited from billing them as soon as
they have to
alerted?
submit? They have to follow the Medicaid. They have to submit the claim to Medicaid.
So there's no requirement that they were informed of the Medicaid eligibility of the individual.
I think it's if they're not told that the patient has Medicaid. I think it's certainly at the point that they're trying to collect. At that point, they should be submitting. Yeah, I mean, it's hard to say that they have an obligation to say that they're not covered, that the service isn't covered by Medicaid, if the patient doesn't present themselves and saying, I have Medicaid. But once they are informed that that patient also has Medicaid, then they need to submit that claim to Medicaid.
I have a question in regards to the provider not being able to bill Medicaid. Usually when you go to a hospital or provider, you have to sign a paper that says if your insurance, what the insurance says that would be covered for benefit, you will be responsible for. Does that consider a consent?
Okay, being billed by Medicaid?
Yes.
Can you repeat the question so that people can hear?
Yes. I was saying that the forms that clients receive before getting services from a hospital or provider, usually they have to sign a consent that says if, and I'm just paraphrasing, if the, once you bill your insurance, if the insurance does it say that it's not covered, you will be responsible for, financially responsible. With that precise, as giving consent to the Medicaid provider that they will be financially responsible if it's not covered by Medicaid?
They have to advise, I think that the law still holds it, they have to advise the Medicaid patients in advance that this service is or is not covered by Medicaid. They have to tell the person, you're on Medicaid, I don't accept Medicaid. It's got to be very clear. The provider has to advise them. This is a service that is not covered by Medicaid, or I'm not a Medicaid provider, and that information has to be done. I don't think that I would interpret that blanket waiver as avoiding the parameters of Medicaid billing. No, they have to tell the person in advance, I don't accept Medicaid, or the service is not covered by Medicaid. We're happy to provide this service, but you will be responsible. I think that's just a blanket waiver. I've never challenged that waiver, but I would think that it wouldn't hold.
So we have a couple of questions from some of the attendees. If the provider is no longer accepting Medicaid, but was at the time of service, can they bill the Medicaid recipient?
No. I mean, when that person went to that provider, that person was a Medicaid beneficiary, that provider was a Medicaid provider, and so the rule holds. They have to, as a Medicaid provider, they're not allowed to bill a Medicaid recipient. The fact that they don't take it 3 years later, no. They were, at the time that they went, they were a Medicaid provider.
The next question, when a hospital refuses to provide the policy, what actions can we take? I have a hospital that is insisting the policy is only available to hospital employees.
No. I would remind them of what the state and local law states. I would bring that to their attention, either verbally or in writing. I'm asking you for a copy of the policy. Under the law, I'm entitled to the policy. Well, the provisions of the law that show that they're entitled to a copy of the policy, and ask them. And if not, I would contact the State Department of Health complaint line. I mean, you know yourself, you can always get that policy from CHOP, but in fact, the hospitals are still required to give you that policy. So that's what I would do.
And there's two resources that are available to people on the agency portal. One is a template letter to make it a complaint about these type of not following the law. And the other piece is that there is the complaint form, as Carol was saying, to make a complaint with the Department of Health that a hospital is not following the policy.
It's important to do that because it's very hard then to get the states to enforce if they say, well, we don't ever have any complaints. We've never heard of a complaint. And so it's really important that if you have a complaint, if you find that the hospital is not following the law, to make that, because that's got to be registered, and then the hospital is more likely to have to deal with it.
This question may have just been addressed, but the next question is, I have a person who applied for hospital financial assistance in October of 2012.
Right.
As of today, she has not received a determination. What should we do?
Contact the hospital financial aid office and go higher up, find out, call the financial aid individual, ask for the supervisor, and say, and remind us this is when it went in, and again, remind them what the parameters of the law are, that you've got to have a response within 30 days, and it's got to be in writing, and perhaps it was an oversight, but here we are now, and I haven't gotten an answer, and you're trying to avoid the person being sued, because they should have had it long before now. And again, make a complaint to the State Department of Health complaint line, because they need to know which hospitals are not following the parameters of the law. Any more questions? I'm going to turn it over to Tashi Liwa.
Good morning. My name is Tashi Liwa. I'm the Consumer Staff Attorney with the Legal Aid Society, and I will be talking in regards to debt collection practices and consumer litigation. Firstly, the debt collection process is governed by the Fair Debt Collection Practices Act, also known as the FDCPA. This is the primary federal law which governs third-party debt collection. It controls what debt collectors may do or say in the process of collecting debts. In New York City, debt collectors must comply with the New York City rules, which are administered by the Department of Consumer Affairs, also known as the DCA. The DCA regulates and licenses debt collectors in the city. New York state law prohibits debt collection harassment. However, there's no private right of action, and the state laws pretty much track the FDCPA requirements. Judgment creditors cannot enforce judgment awards against certain individuals who don't have income or property, or whose income derives from public funds. Those exempt sources of income which are exempt from collection include Social Security disability, SSI, unemployment insurance, veterans benefits, pensions, retirement accounts, and also not included there is alimony, child support, workers' comp, among others. Also exempt from collection is earned income that's less than 30 times the minimum wage per week. After taxes is also exempt from debt collection. Now, currently, the minimum wage is $7.25. So what that means is if the take-home pay is $217 or less, then all of the individual's income would be exempt from collection. If it's more than $217, then 90% of that gross income would be exempt, or 75% of the disposable income will be exempt, whichever is greater. The Exempt Income Protection Act came into effect in January of 2009. This state law protects low-income New Yorkers from seizure of their exempt income that's in their bank accounts. When exempt funds are directly deposited into their accounts within 45 days of the date of the first restraining notice being served on the bank, the first $2,500 is not subject to any restraint. For accounts that don't contain direct deposit funds, the first $1,740 is exempt from restraint. For accounts without, most low-income debtors, the clients that I see at the Legal Aid Society who are receiving exempt, have an exempt income source of income, have less than $2,500 in their account. So all their funds in the account will be exempt from collection. EPA, or Exempt Income Protection Act, is also known as EPA. EPA contains detailed procedures for releasing frozen accounts. If any funds are restrained, you'll have the bank send the account holder a notice and a exemption claim form. It's important that the account holder fill out that form within 20 days of receiving it and mail it back to the creditor's attorney and the bank. It has to be mailed to both. Now, this in turn triggers additional procedures for, let's say, for instance, if the creditor wants to contest whether the funds in the account are exempt or not. If you look at the exhibit, I have a chart. I think it's labeled as the I have the Exempt Income Protection Act chart, and this shows the various steps that are involved when someone has exempt. This shows the various steps that are involved when someone has exempt funds in their income and they want to lift a restraint. Now, similar to EPA, there is a U.S. Treasury rule which was issued in May of 2011. This is similar but not identical to EPA, and this rule strengthens protections for bank accounts containing direct deposited federal benefits such as Social Security, SSI, veteran benefits. This federal rule preempts state law in instances where there is a direct conflict, and in actuality it provides more protection than EPA. The two main distinctions between EPA and this federal rule is under the federal rule, the protected amount is twice the amount of the recipient's monthly benefit. Also under EPA, if the account contains excess funds, the account will remain frozen for a period of 1 year unless the individual debtor takes steps to lift the hold on the account. Under the federal rule, the excess funds are set aside for the creditor and the account will be released. Now I want to talk about the life of a debt, and it's important for advocates and debtors to have, or litigants to have a basic understanding about how a debt is created, who owns that debt, how they go about collecting that debt, and the process is similar for all debts in general, all unsecured debts in general. And I have another chart which shows a slightly more detailed diagram of the various steps that are involved, and from the creation of the debt to collection to litigation. Firstly, and when you look at the life of a debt is created the moment a debtor fails to make a payment. The creditor at that time will usually contact the credit reporting bureaus. They will also assess late fee, and they may also contact the consumer to inquire about why they had missed a payment. If the consumer continues to fail to make a payment, they will send it to the in-house collection departments. The in-house collection departments will usually send out letters, make telephone calls to the individual debtor. These collection efforts can range from being relatively pleasant to quite nasty. The FDCPA, which I'm going to talk more about later, and the New York City rules, the FDCPA does not apply to these in-house debt collectors because they don't apply to the original creditors or their employees. Yet the New York City rules do apply to consumers, do protect consumers against harassing debt collectors, harassing debt collection attempts. Now, at some point, if the creditor is unable to collect on the debt, they will send the particular account to a third-party debt collector. Again, these third-party debt collectors vary in terms of the tactics that they use. One type of collector that we have is the flat-rate debt collector, and they'll send one or a series of collection letters for which they're paid a flat rate. The other type that we have is those who work based upon commission. They'll make phone calls and send letters to attempt to collect on the debt. All these debt collectors, though, will send the account back to the original creditor if they're unable to obtain payment from the debtor. Once we have a third-party debt collector involved, the FDCPA does govern the debt collection process, and the consumer gains substantive rights, such as the right to verify a debt and to cease communication with the collector, both of which I will talk about later. Now, if the creditor is unable to obtain payment through their in-house collections departments or the third-party debt collectors, they at that time have a choice. They at that time can choose to either discharge the debt, forget about it. They can choose to pursue litigation, or the third option that they have is they can sell the debt or that particular account to a debt buyer. Debt buyers are companies that buy charged-off debt from creditors, often for pennies on the dollar, and then attempt to collect on them. They again can try to collect it in-house or use the services of third-party debt collectors. The FTCPA does apply to these debt buyers. Debt buyers who are engaging in collection activity in New York City must be licensed by the Department of Consumer Affairs, since they are considered, they come within the definition of a debt collector. It's common to have these particular accounts sold to multiple debt buyers. So if one debt buyer is unable to collect on the debt, they in turn may sell it to another debt buyer. So we'll see, sometimes we'll see accounts that have been sold to 2 or 3 different debt buyers before it finally goes to litigation or it's discharged. Now, if the original creditor or the debt buyer, whoever has the account at the time, is unable to collect on the debt, they will eventually send it to what's called a debt collection law firm. These local law firms typically send a letter, will attempt to collect on the debt or negotiate a settlement either prior to litigation or even during litigation itself. The FTCPA does apply to these debt collection law firms. Along with state procedural rules, the debt collection firms must follow the federal rules pertaining to debt verification and these communication letters. If during the course of litigation these law firms make false statements or engage in unfair practices, they will be held liable under the FTCPA. This includes false statements in their pleadings or any documents that they submit during the course of litigation. The FTCPA applies to all persons who regularly collect the debt of another. This includes debt buyers, debt collection agencies that I mentioned earlier, anybody other than the original creditor, any party that's involved in the debt collection process other than the original creditor or their in-house collections department, the FTCPA would apply to them. The FTCPA also only applies to consumer debts. These include debts that are incurred for personal, family, or household purposes, which includes medical debts. It does not apply to business debts, parking tickets, or other fines. The FTCPA prohibits collectors from engaging in deceptive or unfair tactics in order to collect a debt, the use of false or misleading statements, either verbally or in written documents. Misleading representations include misrepresentations as to who the collector is when they call an individual debtor, failing to disclose that they're attempting to collect a debt, or implying non-payment is a crime. I had a client a couple of months ago who was a non-English speaker, and she had some debt collector contacting her, threatening to put her in some prison in the Dominican Republic. So this was very upsetting for her, but again, this is one example of what is impermissible under the FTCPA. The FTCPA also bars collectors from harassing debtors by making frequent telephone calls, using profanity, or discussing the debt with third parties. My experiences, or my clients' experiences with that, have usually been in the context of collectors calling their employers and informing them that the employee or the debtor owes money to them. This is impermissible under the FTCPA. The FTCPA does allow collectors to contact third parties, but only for the purposes of confirming their name or their contact information. They can't reveal the fact about how much debt is owed or even the fact that the debt was owed to third parties. The FTCPA also grants substantive rights. Which include the right to verify a debt. Now, within 5 days of a debt collector's first communication, the collector has to send a written notice stating the amount of the debt, who the creditor is, and information regarding how they can dispute the debt. This is often called a G notice because it comes from Section G of the FTCPA. The consumer, once they receive this written notice, has 30 days to request a verification of the debt. Once the debt collector receives this request for verification, they must cease all attempts to collect on the debt. This includes initiating litigation. Now, the actual verification that's required is minimal. It's just the name of the original creditor or the name and address of the original creditor. The main benefit to the consumer of requesting verification is that it halts all collection activity, as I mentioned earlier. Now, this is particularly beneficial if the litigation has not been started yet and the debt is close to the statute of limitations. The New York City rules, the New York debt collection laws are among the strongest that we have in the country. It gives New York City residents a lot of additional protections that are not available under the federal or state laws. For example, under New York City law, collectors have to be licensed by the Department of Consumer Affairs. They must confirm any settlement agreement or any payment agreement in writing within 5 business days. So often the way usually I see this is when we go to litigation, you'll have a collections law firm arguing that, oh, there was a settlement agreement that was reached between the parties through a debt collector, and the client had agreed to pay a certain amount. Well, if it's not in writing, it's not a valid agreement. Furthermore, collectors in New York City are required to disclose certain information if they're trying to collect on the debts who's past the statute of limitations, so they have to inform the individual debtor if the statute of limitations has passed. New York, similar to the FDCPA, New York City also has enhanced verification requirements that are more stringent than the ones under the FDCPA. Firstly, unlike the FDCPA, which says that the verification request has to be within 30 days of the G notice, under the New York City laws, that verification request can be sent at any time. There's no time restraint on it. Furthermore, with the FDCPA, there's minimal verification that has to be provided. Under the New York City laws, there's specific information that has to be provided, such as proof of the agreement to pay the original creditor. With the credit card debt contact, that's the credit card agreement, and the medical debt, I'm sure it's going to be the documents that they signed prior to receiving the services. Also, they have to provide a copy of the final account statement that was issued by the original creditor, a breakdown of the total amount that's due, showing principal, interest, and other charges. And for these other charges, they have to show the date and basis for the charges. If the debt collector cannot provide this information, similar to the FDCPA, they have to stop all collection activity, which includes initiating litigation. I have a sample verification letter that's included. Now this verification letter is under the FDCPA and includes language under the FDCPA and under the New York City laws verification requirements. I know some of you had questions regarding telephone collection attempts. Under the FDCPA, creditors or collectors cannot call debtors prior to 8 a.m. or after 9 p.m. Collectors cannot make repeated or continuous telephone calls with intent to annoy, harass, or abuse any person. Usually you'll see this in the context of having collectors repeatedly having the phone ring to annoy the individual debtor. The New York City also defines excessive frequency as calling someone after the debt collector has already spoken with them twice in a 7-day period. So what this means is if a collector calls a debtor on 2 occasions and the debtor identifies themselves and hangs up the phone, on the 3rd time the debtor can file a complaint with the Department of Consumer Affairs in New York City. Also, if the debtor doesn't want to be called at a particular time and place, it's sufficient that they let the collector know that the particular time and place is not convenient for them, and they don't wish to be called at that particular time and place. And under the FDCPA, that bars them from calling them at a particular time and place. If the consumer wishes to stop all contact with the collector, they can send what's called a cease communication letter. And now this can be simple as a letter just stating, I want you to stop contacting me. It's illegal under federal law to contact me once I've asked you to stop. And that is enough to stop the collector from having any further contact with the individual debtor. It should take about a week for them to receive that letter and process it. But after that, the collector can contact the debtor once just to let them know that they had received the cease communication letter. Often, a lot of debtors want negotiated settlements or payment agreements with the debt collectors because they want to avoid litigation. And consumers should always obtain their settlements agreements in writing. As I mentioned earlier, under New York City laws, Collection agencies must confirm any settlement agreement or any payment agreement within 5 days in writing. Debtors should never give sensitive information to collectors, such as their bank account numbers or the social security number, in the process of trying to settle. One tactic that's really helpful for individual debtors, if they're unable to enter into a payment agreement for the entire amount, which is usually what the collector will be seeking initially, is to hold off on payments and try to save up their money themselves so then they can make a lump sum offering at a later date. The fact that they have a lump sum payment and the fact that they're going to be making the payment at a later date, both work to reduce the total principal, the total amount that the collector is seeking to collect from them. So it's one tactic that can be used. Also, some of the advantages to settling with a debt collector is that the amount is generally less than the claim. It saves a lot of time for litigants. A lot of debtors don't want to go to court because they're going to have to take time off from work. The litigant can negotiate payments over a period of time if they're unable to pay it all at once. And also, they can avoid having a judgment against them, which will show up on their credit report. It's important for debtors to understand all the terms of the repayment agreement or settlement agreement, and it's important that they are able to comply with them. You have a lot of litigants agreeing to payment agreements which are unreasonable for them. And lastly, it's important that if for some reason during the process of negotiations or trying to reach a settlement, if they believe that the creditor is not willing to get to agree to their bottom line, then they should just stop negotiations. It's perfectly fine for them to stop negotiations and let the matter go to litigation or let litigation continue. A lot of debtors feel a lot of pressure that they have to continue with the settlement process. Again, lastly, settlement agreement should take into account the consumer's credit reports. If possible, the settlement agreement should provide that the collection accounts will be deleted from the individual's credit report. Some creditors are willing to do that. In my experience, a lot of them will refuse to do so, but it's worth trying. Debt settlement companies are for-profit companies that target consumers who are in debt, promising to settle their debts for a deeply discounted lump sum. This is a very problematic industry. I generally do not refer any of my clients to debt settlement companies. They require, the basic model that they use is they require consumers to pay a certain amount of money to an escrow account, which is maintained by them. Then this account will presumably compile the savings, which then they will draw upon to settle with a creditor once they've reached a settlement. In most cases, these companies do not settle many debts, if any, and the consumers find themselves in a worse position. Generally, it's really bad news simply because in just about in all cases, these companies will advise the debtor to stop making payments to the creditors and start making payments to them into their escrow accounts. So what this means for the debtors is that they default on their payments, they're taken to court, and the company does not enter into negotiations with the creditors for a long time, and they make no guarantees about assisting them in court. They don't provide any assistance to these individuals who have lawsuits against them. Currently, New York State does not have any comprehensive regulation of these debt settlement companies. A lot of states have banned them. I believe Hawaii, New Jersey, North Carolina, Louisiana are some of the states that have banned debt settlement companies altogether. Some other states, such as Illinois, have comprehensive regulations. I'm going to talk about the telemarketing sales rule in a second, but it's a piece of federal legislation that regulates debt settlement companies. But currently, in New York State, there's one thing that the telemarketing sales rules even fails to do is it fails to cap the fees that can be charged by these debt settlement companies. And in Illinois, they placed a 15% cap on the fees that can be charged by them. The telemarketing sales rules is the Federal Trade Commission's amendment to the telemarketing sales rule is the most significant development in the regulation of these debt settlement companies. It went into effect in October of 2010. It applies to all outgoing calls by debt settlement companies as well as incoming calls by consumers in response to advertising, and imposes strict regulations on debt relief services, which includes debt settlement companies. What it does is it imposes limits on some of the more harmful aspects of this industry, including a ban on upfront fees, replacement with that of some pay-as-you-go fees, the requirement of key disclosure, prohibition on misrepresentation. What it does not do, it doesn't apply to in-person or internet-only sales of debt settlement services and exempts attorneys. So what you'll have is you'll have a lot of these companies now having attorneys. They'll use an attorney model without any meaningful participation of an actual attorney. So this is a way they can avoid the ban on upfront fees or advance fees. Something that the TSR fails to do, as I mentioned earlier, it fails to put a cap on the amount of fees that can be charged. I had a client come in 2 weeks ago, was taken advantage of by a debt settlement company, which of course can't charge him advance fees, but they're charging him fees of 36% on the actual savings, which is a ridiculous amount. If the claimant or if the creditor decides to pursue litigation, it has several different forms depending on the amount of the claim. New York civil courts will usually take claims that range from $5,000 to $25,000. Claims below $5,000 will usually be heard in the small claims courts, and claims for amounts above $25,000 will be in the Supreme Court. And this is for within the 5 boroughs. Now, if a claimant wins a case, the court will enter judgment for a certain sum of money. The money judgment is legally enforceable for a period of 20 years, and it accrues interest at 9% a year. This 20 years is renewable after each payment. If a judgment debtor refuses to pay, the creditor can then go to an enforcement officer, which is usually a sheriff or a city marshal, who could then seize the debtor's assets to pay the judgment. The creditor, again, pays a fee to the enforcement officer of 5%. This is added to the judgment. Pays a fee to the enforcement officer, and this fee plus a separate charge of 5% of the judgment is added to the balance owed by the debtor. When the judgment is entered, the enforcement officer will often send a packet of information, a packet requiring specific information regarding the debtor's income and assets. The debtor must complete that packet and return it. Otherwise, they could be looking at fines or even jail time. The creditor may also send information subpoena, which also has to be responded to by the individual debtor. There are several ways that a creditor may go about trying to collect on the debt once they've got a judgment. One way is by freezing the individual debtor's bank account. The rules I mentioned earlier about EPA do apply here. Another way is a creditor can collect on the debt is by garnishing the debtor's wages, which is for a maximum of 10% per pay period. And again, if the debtor already has child support, alimony, or support payments taken out of their paycheck, the total amount garnished cannot exceed 25%. All the rules that I mentioned earlier about exempt income are in effect. Those exempt sources of income are exempt from collection. Lastly, a creditor can also take out a lien on the debtor's home or property. What this means is if the debtor sells the property or home at a later date, the proceeds from that sales will first go to satisfy the lien. Subsequently, whatever's left over will go to the debtor. Docketed judgments becomes a lien on real property, even if the real property was obtained subsequent to the judgment being entered. It's showing up to court, showing up and answering the court complaint or court papers is actually half the battle with these with consumer debt cases and also in medical debt cases specifically. It's very important that the debtors show up, assert their rights, and answer the court papers. I know Carol talked earlier about some of the defenses that relate to, for low-income individuals with Medicaid and some of the reduced payment options that are there. The defenses I want to talk about are general consumer defenses that are applicable to all consumer debt cases. Firstly, in regards to lack of personal jurisdiction or improper service, CPLR 308 governs the service requirements. There's 3 ways that individuals can serve someone when they're initiating a civil case. First is by personal service anywhere in the state. Second is by substitute service at a person's principal place of business or at their residence on someone of suitable age and discretion. They also require shortly thereafter that the creditor send a copy of the summons and complaint by mail. The third way to serve them is to go to the debtor's principal place of business or their residence on 3 separate dates at 3 separate times. And if there's nobody there at the residence on the third time, they can affix a copy of the summons and complaint to their front door. And they're also required to send a letter shortly thereafter, a copy of the summons and complaint by mail shortly thereafter. All of this has to be done by a licensed process server. If service is improper, the litigant can choose to make a pre-answer motion to dismiss based upon improper service or file an answer containing a personal jurisdiction defense. If they choose to include a improper service defense in their answer, they have to file a motion to dismiss within 60 days of raising that defense in their answer. Also, on the return date on that motion to dismiss, the court will either decide to grant a traverse hearing or not. If they decide to grant a traverse hearing, the defendant must testify and should gather evidence regarding improper service. At the traverse hearing, you'll often have the creditor's attorneys try to argue the merits of the case as to whether the debtor owes the money or not. It's important to bring the traverse hearing is only to determine whether service was improper or not to discuss whether money is owed. Lastly, the defense of lack of personal jurisdiction has to be raised in the first instance. This means it has to be either raised in the answer or when you amend the answer as of right, which is within 20 days. It cannot be raised for the first time in a amended answer which has been brought through a motion to amend. Okay. The statute of limitations for medical debt cases is 6 years. I'm going to skip this so I have some time to answer some of your questions. It's pretty self-explanatory. For medical debt, it's 6 years. It's important to remember that a mere threat of a lawsuit where there is no actionable claim, such as when the statute of limitation runs out, is a violation of the FDCPA. CPLR 202 states that when you have a foreign entity that's suing a New York residence, we look at the statute of limitations of where that foreign entity's home state is and where the defendants, and the New York statute of limitations. And if the foreign entity's home state statute of limitations is less than the New York state, which is 6 years, then we apply that. For example, if I'm not sure how applicable this is in the context of medical debt, but in Delaware, the statute of limitations is 3 years. If we had an entity-based Delaware, we would be applying a 3-year statute of limitations. Lack of standing. This defense applies when the plaintiff is not the original creditor, when we have a debt buyer. Often you have an assignee that's suing on an account that was allegedly purchased from the original creditor or another assignee. When this is the case, the plaintiff has to provide proof of assignment. And in the case of where you have 2 or 3 separate assignees where an account has been sold to multiple debt buyers, the plaintiff then would have to show proof of the entire chain of assignment. So all the assignment contracts and the contract between the original creditor, between the original creditor and the individual debtor. Identity theft or mistaken identity, it's pretty self-explanatory. Identity theft occurs when someone steals the defendant's name or personal information. Mistaken identity occurs when the defendant has been confused with someone else or who has a similar name or identifying information. The general GBL 514 provides for attorney fees in cases where the judge finds the defendant has cooperated with the issuer and the issuer brought the action nevertheless. Also, a counterclaim can be brought under the FDCPA if the litigant has informed the consumer on a prior occasion that he or she is the wrong person, because it forbids the collector or the plaintiff for communicating with any party other than the consumer about the consumer's debt. It's also important to raise potential counterclaims. GBL 349 is the New York State statute, which is constantly raised in the consumer debt context. What it states is that deceptive acts or practices in the conduct of any business, trade, or commerce in the furnishing of any service in the state is declared unlawful. You have a lot of debt collectors and attorneys using deceptive tactics to get payments or to get the individual debtor to default. GBL 349 creates a private right of action. The litigant can recover actual damages or $50, whichever is greater. Also, the court can grant triple the damages up to $1,000 if it finds the defendant willfully or knowingly violated this section. Some examples of what would be considered deceptive business practices would be if you have let's say you have a home law litigant who gets served with court papers, and when she contacts the attorney or opposing counsel, the plaintiff's attorney, she gets told that she doesn't have to show up to court and she should just make a payment, and later on this attorney gets a default judgment against her. Another example of what could be considered a deceptive practice would be if you have an individual litigant who gets served with 2 different summons and complaints with 2 different index numbers by 2 different law firms, all within a couple of weeks of each other. That could potentially also be a deceptive business practice. Again, with the FTCPA, they could also be raised as a counterclaim. There are a number of protections which can be provided, including prohibiting contact with third parties. I discussed that earlier. Prohibiting harassment and abuse. Prohibiting false, deceptive, or misleading representations. Misleading representations could be, when you have collectors trying to collect on debts that are past the statute of limitations. If you have debt collectors threatening to arrest or imprisonment, they don't have the authority to do that. And also, if there's false representations, that they don't need to respond to documents that they're served with. The court can award actual damages or statutory damages. Statutory damages are $1,000. The Second Circuit is right now, the case law is still vague as to whether it's $1,000 per case or per each incident or for each violation of the FTCPA. And lastly, I have some referral resources for legal services organizations that assist with consumer debt cases, some bankruptcy projects, and other helpful resources. So at this time, if you have any questions.
So we have someone asking, can a consumer attempt to negotiate the amount? Should they be encouraged to do that?
Yes, I would encourage them. They can negotiate an amount, and I would encourage them to do that. They just have to bear in mind some of the things that I mentioned earlier. That there are particular tactics that can be used. They should always try to enter into agreement for a payment plan that's affordable for them, because you have a lot of people that feel pressure to enter into agreements which they can't afford. Also, it's important to remember that there's no obligation on them to settle. They can back out at any time they want to pursue litigation. And as I mentioned, it's not only with medical debt cases, but with consumer debt cases in general. Almost none of these cases go to trial. So if they stick with it, they have some defenses and rights that they're unaware of, which they can find out about later. So they should feel no obligation to enter into negotiations or settle. I would encourage them to contact. And there's different benefits to negotiating prior to litigation and negotiating during litigation itself. They can negotiate anytime. They can negotiate before it goes to collections, during collections, prior to litigation, in litigation, and actually, on the trial date itself. One tactic which I'm going to mention again that I think is very helpful is instead of trying to settle at the time the collector first contacts them for the entire sum of the debt, if they wait and they try to save up some of the money so that they can offer a lump sum amount, this makes a lot of the collectors or creditors are willing to give you a reduction on the amount that they claim. Also, the mere fact that you're waiting to pay off on that debt also gets a lot of creditors, because creditors want to be paid soon, so the longer that they're not being paid, the more willing they are to reduce the amount of the claim.
Are there any other questions?
I had a question. All right, so at the last meeting, and I guess this is just a general question, we had someone that had a medical bill for a helicopter or the transport by helicopter. So is there any general rules that you would give in terms of how to just negotiate that debt, or because most insurance don't cover the medevac. If there's an emergency, you have to be transported from, I don't know, accident scene to a hospital.
it covered? What covered insurance?
Well, sometimes it's Child Health Plus, sometimes it could be private health insurance that it has. But it's just that that's a service that's not covered by the health insurance. Is there anything else they can do other than negotiate with the helicopter provider or the?
Well, I mean, I'm sure that the insurance company would have their own appeal procedures, so that they should pursue. I would say they would pursue.
Appeal. Yeah, it's Medicaid. Just, I guess, deal through the plan if it's up, but it's not at all covered. It's definitely a non-covered service.
Mm-hmm.
And I would have to check and see whether it would be covered by Medicaid. I don't know if it would be covered by.
If not, would they qualify as a healthcare provider and considered from something like that from Medicaid?
That's an interesting question. Would they have to tell somebody that this particular service is covered by Medicaid, that they can't bill for it? I don't know whether I don't know if they would be considered a provider. The transport company is a provider. I'm not sure that the transport company is a provider. I would have to check on that. I'm not certain. I can certainly look into that. Do you have somebody that has a debt from a transport from a helicopter?
Right. So I mean, what they ended up doing is just negotiating. They reached out. The bill was like about $25,000.
Right.
They reached out first, and the company reduced it, let's say, to $15,000.
Right.
And then they had to work out a payment plan to pay off whatever that $15,000.
Right. I mean, I would definitely encourage them to look into the policies.
Look into the policy. Yeah.
But I mean, it's one thing I want to mention though is it's really important that you, before you sign anything, any settlement agreement that you entered into, which is a typical tactic that we use, they'll always give a reduction on the claim. As you mentioned, your claim is down to $15,000, and then they'll have them enter into a payment plan. It's very important to read the terms and conditions and make sure that they're able to afford the plan or think about whether they really want to enter into a payment agreement, because once you sign any settlement agreement, it is very difficult to back out of. I mean, short of arguing that there was some fraud committed against you, where that there was some coercion involved by the opposing attorney when you entered the settlement agreement, it's almost impossible to back out of those settlement agreements once you enter into them.
And also with Family Health Plus, do the same rules apply in terms of balance billing, or it's just strictly for Medicaid?
So the same rules. Family Health Plus is a Medicaid product. So the same rules hold, but whether or not somebody is eligible, of course, is different. So of course, Family Health Plus coverage is prospective, not retroactive. So you might have somebody who might be not covered because the bill occurred prior to. Actually, Tashi and I have a case like this together that involved somebody who applied for Medicaid, okay, claims they went to, came to the United States pregnant, went to the hospital, admitted to the hospital by her obstetrician, then applied for Medicaid after she got out, okay, like within that month. And she was approved for Family Health Plus and not PCAP, not pregnancy-related Medicaid. And so was covered prospective and not retroactively to cover the hospital bill, and is being sued. So Tashi's handling the litigation aspect, going to court, the Traverse hearing. We're handling the Medicaid portion, so trying to see if we could figure out a way for Medicaid to cover, because if Medicaid knew she was pregnant, she should have been entitled to retroactive coverage, even if it was just Medicaid coverage up until the time she was on the plan. And so the way it stands now is that she went to a fair hearing and got a ruling that Medicaid, that HRA is going to determine her eligibility for Medicaid during that coverage period. Even though the bill was old, 5 years old, she never challenged their determination, when she was found eligible for Family Health Plus. That was 5 years ago. She never challenged that within that 60-day period. So there are lots of reasons why they would not have considered it. But anyway, they went to look to see if they could get the application, to see if Medicaid at the time knew that she was eligible for that she was pregnant and that she should have been. So that's sort of an example of where we're kind of handling these cases together. But that's the case where Family Health, she wouldn't have been entitled to Family Health Plus coverage, but Medicaid coverage. But the bottom line is, if somebody's covered by Family Health Plus, the same rules about balance billing hold. But the point of coverage, the point of eligibility for coverage varies.
Great, thank you. So if no one else has any questions, I want to thank Carol and Tashi for coming in today, for giving us this information. And you have the last slide have different resources for all the upstate counties. Empire Justice Center, Jeffrey Hill, is available to assist you, give you guidance if you need to look up different laws. Tashi mentioned federal laws, and then he mentioned some New York City rules that applies for just the 5 boroughs. So Empire Justice Center is available for all upstate. Legal Aid Society is available for all downstate. And Long Island is also covered by Empire Justice Center. So if you need any help, if you need any resources that we mentioned today, they're available in the portal. As Drew mentioned earlier, we have the hospital financial assistance, all the different things that they're allowed to ask for and not allowed to ask for. We have that letter that's available that you can customize to your client. As Carol mentioned earlier, if you have problems with hospitals in terms of hospital financial assistance, reach out to them directly and also file complaints with the New York State Department of Health. The number was given in the slide. All right, so thank you for coming today. If anyone has any questions, you can always email myself. You should have the slides. And this webinar was recorded and will be available for reference if you need to review it. We're going to post it in the CHOP portal, if not tomorrow, sometime next week. So thank you for coming, and everyone enjoy the rest of your day.